Nancy, I work with a lot of young residents and medical students, a lot of young professionals as well. And what I'd like you to share with us a little bit is the three things that you think are the most important things that people in that position might want to pay attention to. A lot of them are single, but some of them are married, and some of them are married with kids. Mm-hmm. So if you kind of share your experience on that,
it's hard to distill into three things, but I'll try.
Okay.
The first thing is that to realize, for anybody to realize, is that estate planning is a process that really needs to take place over time. Certainly, everyone needs an estate plan. And by estate, I mean addressing the property that you own and addressing personal decisions relating to powers of attorney and things like that. But when a person turns legal age, and in Ohio that's 18, that person ought to have legal documents. I've done some speaking in high schools, and I've said, if you've got a boombox and money in your wallet, you've got an estate plan. And so, but we're assuming that medical students and residents are going to have a lot more than a boombox and money in the wallet, you know. But certainly, so there are certain legal documents that need to be done really at the beginning of legal age, like a will and a general power of attorney and healthcare directives, a document in Ohio called a right of disposition of remains.
Right.
That we do those documents for 18-year-olds, whether or not they are married. And then as they age and marry and accumulate wealth, then we may add documents to their estate plan portfolio, such as a trust for to defer distributions to children,
right,
beyond age 25 in Ohio, or a prenup.
Right.
Certainly, and that really gets into, I'm kind of blurring my answer here, but my second part of that three most important things is really asset protection planning.
Right.
And so as the young doctor accumulates wealth, if she or he is not yet married and going to get married, I would counsel that person to get a prenup. Mm-hmm. For the purpose of protecting what has been accumulated before the marriage from divorce or other unfortunate circumstances.
Sure.
And then as the wealth increases, there could be kind of a change in the type of trust that we do to address federal estate tax planning.
Right.
We currently have a $11.2 million individual federal estate tax exclusion amount.
So that means that they can have that much in assets and not pay any federal estate tax.
That's right.
When they die.
That's right. Or if they're married, the couple can actually shelter over $22 million from federal estate tax.
So it doesn't apply to a lot of people anymore.
That's right. It doesn't. Now, that figure has a sunset provision in it.
Right.
That it's going back to 5 point something back in 2025.
Right.
Yeah. So basically the first thing to remember is that estate planning is a process. Oh, and then some documents can be time sensitive.
Sure.
Like powers of attorney. Financial institutions are skeptical of old powers of attorney, for example.
As well they should, because lots changes.
That's right.
Quickly.
That's right. And so what worked this year may well not work 10 years later.
Right.
In the estate planning process. And people get frustrated by that. They don't necessarily like paying lawyers any more often than they have to. But that is a reality of life. And then also, if the people who are listening to this may move to another state,
right,
they're going to need to consult with a lawyer in that state as well.
Right. So you talked about if somebody had a boombox, and money in their pocket, you date me. I know what a boombox is. We both do. But I think today we'd be talking about an iPhone and money
right.
in their pocket. But one of the things that I think of around that is that young people, whether they're 18 or 21 or 25, they're acquiring things. They're in that point in life where they're accumulating personal possessions. But one of the things that we often don't think about is the question of incapacity. I have a story that was related to me by a state attorney of a young person who was a walk-on at Ohio State University. He was in spring practice and he went across the middle to catch a pass and he got hit hard, came down awkward, and was paralyzed, broke his neck. His parents, they called his parents, they took him to the hospital, they called his parents in Upper Sandusky, they came down to the hospital. Well, the hospital wouldn't talk to him.
Right.
Because this is a person of legal age.
That's right.
And HIPAA laws don't allow them to share that information. And he was so incapacitated that he couldn't give permission.
Oh my.
Now, those people, those parents were desperate. Now, at the time, Jim Tressel was the coach at Ohio State University, and Jim Tressel knew a probate court judge, and he called that judge on the golf course and had him come to the hospital and appoint the parents as guardians of their son, who could not answer at that point. Now, the truth is, not everybody knows a probate judge, or not everybody knows someone who can get a probate judge on short notice.
Right.
And those are situations where those are the things that I counsel my clients, that when they have a son or a daughter who's going off to college, has turned 18, that you need, at the very minimum, you need that healthcare power of attorney for your children, not children anymore, but for your son or daughter at that point in time. So talk a little bit about incapacity. I mean, that's a whole different issue that a lot of people don't think about.
It is. And I've got my own war story to tell. When my first husband, David, was in the hospital in intensive care for 3 weeks before he died. And we had a car title that the registration expired. And I did not have a power of attorney for David because, and that was going to be my third point, in your answer to the three most important things, is get specialists, get a lawyer who is a specialist in the area of estate planning. Well, David and I didn't do that. We went through the Bar Association and actually got assigned a lawyer who turned out to be a bankruptcy lawyer. And he gave us exactly what we wanted. We went there for wills, and he asked us what kind of wills we wanted. And he said, well, you want a simple will? I guess, simple will sounds good. We don't have it.
Simple sounds good,
much,
right?
But we walked out of there without any discussion of powers of attorney, healthcare directives, or anything. And so fast forward, not even a year later, and I could have used a financial power of attorney to renew the car registration, and I didn't have it. And consequently, I got a ticket, and I ended up in the police station bawling, and making a fool out of myself because Dave was in the hospital and they thought I was this nutty, crazy woman, and that sort of thing. But just something simple like that is so important. Disability will happen to us during our lives before death will, at some stage. The famous cases, now I'm kind of flipping here to healthcare directives, but the famous cases in the United States about healthcare decision making, Terry Schiavo, Nancy Cruzan, they were young women who did not have documents, and the courts had to get involved. And so, and so for that reason, we all need healthcare directives again. And I would mention, most people tend to think of like a living will. And I tell my clients when I meet with them, the healthcare power of attorney is the most important document. That's a document in which a person designates someone else to make the healthcare decisions.
And I do the same.
Critical.
And so your personal experience with the car registration speaks to the point that you need to work with an attorney who knows the area of law that you're consulting with them about. And there are specialists in law, just like there are specialists in medicine.
That's right. That's right. There are maybe 150, 175 of us in Ohio who have gotten the credential certified specialist in the area of estate planning, probate, and trust law. And the Dayton Bar Association has a list of us who who have the specialization.
So if somebody's looking for one of those,
Yeah.
that would be a place for them to start.
Any lawyer in Ohio is allowed to write a will,
Right.
or allowed to write a power of attorney.
Allowed to and should are two different things, though.
I did an estate plan for a domestic relations lawyer, good friend of mine, and when he looked at the power of attorney, he says, "Geez, this is a lot better than mine."
Well, it should be.
Well, yes, that's because I've considered all these other things that you wouldn't necessarily. He's a great DR lawyer,
sure,
but we don't know what we don't know. I've chosen to be focused and be excellent in the areas of estate planning and probate.
Well, thank you very much.
You're welcome.